Usual personal injury case that doesn't involve insurance. There is an insurance policy that usually is on the other side, that usually protects, and the fancy word is indemnifies the defendant, and will pay money and will hire an attorney for the defendant. But people may not quite realize that insurance is not in the caption. The insurance company is not listed. It is, for example, John Doe versus Jane Doe. It is not John Doe versus an insurance company. And that is consistent with the rule that we cannot mention in a courtroom where there is a trial the existence or the non-existence of insurance. And by the way, if we can't mention whether there is insurance or not, we certainly cannot mention the amount of insurance. And that kind of blindness or uncertainty has its reasons in the law, and many of the leading treatises, we'll call them, have shown that in all the states in the country, insurance is not permitted to be used or mentioned in a trial. There are a few very small exceptions, and we'll get to that later on in this blog. But again, in your so-called garden variety tort case, your garden variety personal injury case, your accident case, you cannot expect the amount of insurance, of course, nor the fact that the defendant is insured to be mentioned. And why is that? I suppose it's pretty clear. The experts say that it would lead to the introduction of inflammatory evidence. It will cause people to make decisions that are not based on the facts, that are not based on impartiality. And similarly, just as a plaintiff is not permitted to bring up the existence or not of insurance, the defendant should not be able to bring up the fact that the plaintiff has access, say, to workman's compensation. Again, it's a two-sided rule, or a twofold rule. We could say it's symmetrical, because I, as the plaintiff's attorney, the person suing, would not want an insurance company to say his client has already gotten some sort of compensation. They've got it in the form of workman's compensation. No, I strenuously object if there's any attempt to raise that in a case. And that is because I would not want the fact finder to think that my client has had some compensation for this injury or accident that they are entitled to bring in a court, as opposed to the Division of Industrial Accident. In other words, it is not fair to bring up the existence of insurance when it indemnifies or compensates the plaintiff, the person suing, just as others say, and in fact it's the rule, you can't bring up the existence of insurance on the part of a defendant. I mentioned the rationale, which is that the idea is to have the fact finder, the jury, find based upon the facts. And I also mentioned that there are some exceptions, and basically the exceptions come down to two things, and that is where an insurance company is a party for some reason, not in the so-called garden variety tort case, but also where there is evidence or there's a dispute regarding control. Who had control of a particular area, say, where there is a premises liability accident, and the act of getting insurance tends to indicate who at least thought they had control of that particular area. And then finally, occasionally insurance can come in to show the bias of a witness. But I want to stress again that the instances where insurance is permitted to be used is a very minute part of the personal injury field and the personal injury cases. Thank you.